Well, we seem ready to resume, but before we do, I will give the floor to Annalisa because she has an announcement to make.
Thank you, Mr. President. If you'll just indulge me for a few seconds, I should have done this at the beginning of the session, but I wasn't able to. I just wanted to say a few words in remembrance of our esteemed colleague, David Kasdan, who passed away recently, and I wanted to reflect upon the invaluable contributions he made to the field of international arbitration. His meticulous dedication to capturing the essence of legal proceedings, his unwavering commitment to accuracy, and his role in preserving the integrity of the legal record have left an indelible mark on our international arbitration community. He always undertook his work with a quick sense of humor. He had been around for over 20 years, covered many cases, many big cases, and he always was wonderful. He was full of wonderful stories of all the cases he covered. He was an invaluable part of the ICSID system, and we will miss him terribly as we carry on. Don, thank you for stepping in for David during this time. He was supposed to be covering our hearing, and I just wanted to thank Mr. President for allowing me a few minutes to honor David. Thank you.
Many thanks, Annalisa. I think we all join in your words of gratitude to him, and probably the parties as well share this same feeling. So, unless there is anything else for you to raise at this point, we can just resume with the hearing, and with Clement's rebuttal. I think you will have 45 minutes as agreed. Mr. Fleischheimer, you have the floor.
We will do a sequential presentation, starting with Mr. Porter, then myself, then to conclude, Mr. Derman.
Yes, members of the tribunal, Mexico, in their opening, asserted that the waiver for Drake Finley relied upon submitting the piece of paper in the statement of claim. But that's just incorrect. If you look at every tribunal that has addressed this issue has sided with claimants. And if you look at the language the International Thunderbird Gaming Corp said, that the tribunal joins the view of other NAFTA tribunals that have found that Chapter 11 provisions should not be construed in an excessively technical manner. And what they mean by that is, when you do not have a concurrent proceeding, then you have complied with the waiver requirement under NAFTA. All of the cases that Mexico has cited all had concurrent proceedings, including KBR. It was a concurrent proceeding. That was a material violation of the NAFTA Article 1121. But our case is the most similar to International Thunderbird. We discontinued any proceeding we had in Mexico, and the only thing we did was submit the piece of paper, the waiver, with the reply. The only party that continues to proceed in Mexico on a case is Mexico for the Durama bond. Regarding the Durama bond, Mexico again asks you today to analyze that Durama bond in isolation. They act and ignore.
Señor Presidente, me veo en la necesidad.
Mr. President, I need to apologize to claimant. We do not know, and we don't know if these slides that we're looking at is new material or this is coming from the previous slides. But I would like for this to be shared with us, and not only this, to share this with the tribunal. So so as not to impact on the time that claimant has, we would deeply appreciate if you could share with us, not only with us, but also with the tribunal, this material, the presentations.
I don't know whether you have any objection to doing it now.
Yes, it's in transit, but it should be coming over momentarily.
Well, just by email. I think.
Yes.
Okay.
Correct.
So, Mr. Porter, you can go on.
Thank you. So Mexico again asks you to analyze the Durama bond as an investment in isolation. They ignore specific clauses in the contract that called on the Durama bond. In fact, if you look at clause 10.1, it says, in order to guarantee the fulfillment of the obligations of the 821 contract, that Finley Resources and the parties to the 821 contract must obtain a Durama bond. You must analyze the Durama bond with the risk of the 821 contract. If you even look at the Durama bond itself, Mexico states it did nothing to further the 821 contract's overall purpose to essentially increase hydrocarbon production. But the Durama bond's obligation was pretty clear. It was in that document. It was for the comprehensive work of drilling and completion of inland wells in the northern and southern regions of Pemex, of Package 5. That came from the Durama bond itself. Also, again, Mexico ignored the fact that it's treating the Durama bond as a penalty, not some guarantee, but as an asset, as collateral to go after. It never addressed that after we raised it in our opening. Mexico also insinuated that the Durama bond and the 821 contracts are not investments under ICSID Article 25, and they mentioned the Selene test. Selene is the preeminent case for ICSID Article 25. It's the one everyone cites to. And if you look at how other cases have described what was happening in Selene, it's this. It is not disputed that the claimants used their know-how, that they provided the necessary equipment and the qualified personnel, that they set up the production tool on the building site, that they obtained loans to finance the purchases necessary to carry out the works and to pay the salaries of the workforce. And finally, that they agreed to the issuing of bank guarantees. Those are the exact actions the claimants took in this case in Mexico. Mexico mentioned Selene, but then didn't address what Selene held. It's when you do these things, then you qualify under Article 25. Also, Mexico made a mention about investment risk and risk in general. And they tried to argue that claimants only took on a commercial risk in this case. They didn't take on an investment risk. Mexico provided the definition of what they think an investment risk is. It's one that may not know the amount he will end up spending, even if all the relevant counterparties discharge their contractual obligations. Where there is risk of this sort, the investor simply cannot predict the outcome of the transaction. That was definitely the case here for claimants. Also, Mexico in its rejoinder, and it made a similar argument today in its opening, said this about the risk that claimants face. They said the reality is the respondent considers it unfortunate that the claimants attempt to justify that the lack of expected production at the Chicontepec constitutes a breach of their alleged investments. Again, the claimants always recognize the complexity and challenge of the Chicontepec and the consequences the fall in oil prices would have had on various projects, which in turn generated high costs for the extractions of hydrocarbons. But the issue there is, claimants did not take on the risk of the fall in oil prices in the contract. But what did Mexico do? It flipped it. It put that risk on claimants. When it did not want to take that risk, it made claimants take that risk, and then today they're trying to justify what happened by saying that was not their investment risk. Also, Mr. Bonfilio said that the definition of investments under the contracts should be, I think the word was, are not broad or are not, do not cover, are detailed. But I ask that you again read what the definition of investments are under these treaties. If you see under the USMCA, it is every asset that one owns and controls that has the characteristics. And one of those characteristics is risk, like I just talked about before. And claimants provided evidence of the importation of the equipment. Mexico argued that we have not shown how the equipment got to Mexico or who took it. And here it was. If you look at C-161, we provided importation documents that equipment was taken into the hands of Drake Mason, Mexico. That was the company that took ownership in Mexico permanently. And you'll hear Mr. Jim Finley and Louise Kernian talk about that. Mexico, on several occasions, argued that the claimants are merely making contract claims and then it's investment arbitration. And they cite to Waste Management 2 to support this. But if you read Waste Management 2, it has a definition of what constitutes an Article 1105 FET breach. And I think it is a great definition to say what goes beyond a mere contract claim into an investment claim. And that's exactly what happened here, and that's exactly what we are arguing. And that tribunal said that there has no doubt that a deliberate conspiracy, that is to say, a conscious combination of various agencies of government without justification to defeat the purposes of an investment agreement. That's what happened to us. There was various agencies, the Mexican court system, Pemex. They got together and they defeated the purposes of our investment agreement. And Mr. Lucenow summed up that objective well when he was talking to Mr. Kernian. Your companies are done. That's what took it beyond a mere contract claim, and that's when a reasonable person would have even known that they had an investment breach, October 2018. Also, Mexico, to support their procurement argument, relies on Mercer versus the government of Canada. And it's interesting, if you look at that case, and I mentioned this earlier, but we'll expound on it here, since Mexico cited it as support for their argument. Mexico made a Rule 1128 submission in that case, and they stated all of the contractual terms and conditions fall within the ambit of the term procurement. That means if there's a procurement part of a contract, then that entire contract becomes a procurement contract and falls under the exception. This was an 1128 submission. The tribunal didn't have to do what they did, but they went out of their way to disassociate from such an interpretation. The tribunal says, nor conversely, does the tribunal accept Mexico's submission under NAFTA Article 1128 that all of the contractual terms and conditions of a procurement contract fall within the definition of procurement. You see here, the unequal treatment was Mexico's actions to get out of the 803, 804, and 821 contract compared to the 809 contract. Mexico paid the holders of the 809, and they did not pay us. That has nothing to do with procurement. Mr. Melsheimer is going to talk now about the facts and the merits.
I'll be brief. We heard a lot about how the contracts expired on their own terms, they ended, they terminated. If you use the casual word terminate, okay, the party's performance terminated. But contract words mean something. Read the contracts. They're very clear. The 821 contract, it says, and I put it in Spanish and we put the translation in English for those who don't speak Spanish. The term of the contract will end once the settlement is formalized or in the event that it results in balances of favor of any of the parties on the date on which the corresponding amounts are paid in full. This finiquito, you'll read, is incorporated into the contract itself. There's a reason why that happens, because guess what? The contract remains alive. So much so, Pemex acknowledged it in its unilateral finiquito in November of 2021. It told us, it tells you in Exhibit R43, the closing of this contract will take place once the contractor pays the indicated quantities in full. Query: how is a contract still open if it's been terminated? It's not. Again, I'll look at the 803 contract. That contract is very clear, has a clause. It's not in the finiquito clause. It's actually a clause called validity. That clause says, the validity of this contract begins from the date of signature until the legal act by which the rights and obligations of the parties are extinguished in their entirety is formalized. Question: have the parties' rights and obligations been extinguished under the 803 contract? No, they have not. Why not? The finiquito for the 803 contract has a big reservation of rights in it. By definition, under the clause 803 under the 803 contract, clause 2, the contract remains alive. And again, just like the 821 contract, this clause or the finiquito, is incorporated into the 803 contract. Likewise, the 804, which is very similar to the 821 contract, and we'll see in a second, very similar according to Mr. Asali to the 809 contract. The 804 contract, in its finiquito clause, clause 18, it says the same thing. The term of this contract will end once the settlement is formalized or in the event that results in balances in favor of one of the parties until the date on which the corresponding amounts are paid in full. Question: have all the amounts been paid in full under the 804 contract? No, they have not. In the finiquito for the 804 contract, again, there is a big reservation of rights. We were trying to enforce those rights before a Mexican court for over 5 years without adjudication. Similarly to the other contracts, this clause, the finiquito of the 804 contract, is incorporated into the 804 contract. The contract is still in existence by its own terms. When we talk about the like circumstances, there was a lot of, I would call it hair splitting, trying to find distinctions where really no meaningful ones exist. We heard about hurricanes or tropical storms and types of work. All I can tell you is what Mr. Asali tells us. He tells us that the structure of the 804 contract, excuse me, not Mr. Asali, it might have been in the opening. The structure of the 804 contract is similar to that of the 803. According to Mr. Asali, 804 is nearly identical to the 809 contract. I invite you to compare. The 821 contract is not that much different from the 804 and the 809 contracts. And if you look, again, we wanted to talk about declaring force majeure for a flooded well. Look at the amounts that were paid to the Mexican nationals holding the 809 contract. You tell me, what were they paid for? $13.4 million for lack of assignment of work. We were not paid that amount. We spent 5 years in 2 different courts with the 803 and the 804 contract, and we got greeted with an administrative rescission for the 821 contract. We heard about Pemex and how it somehow, I don't know, at one point I heard it's an organ of the state and part of the state. Then I heard that, well, except in investment treaty world, then Pemex does not become part of the state. I just look at the Pemex Law 2008, Article 2. It's pretty clear. The state will carry out the activities that correspond exclusively to it in the strategic area of oil through Pemex and its subsidiary organizations. The state acts through Pemex when looking and exploiting oil. Pemex was acting on behalf of the state when it entered into our contracts. Everyone has heard they're all called administrative contracts. That's not a normal contract, and there's a reason why they're administrative contracts. They're on behalf of the state. Now, I also heard that the administrative rescission was based on a expanded list. It wasn't really two things, it was an expanded list of violations of the 821 contract, and we were portrayed as somehow being bad actors. That's not what Pemex told the administrative court. Read it for yourself. They acknowledged their two primary, what they would call breaches. The fact that we didn't perform this work order, 028-2016, and I emphasize, after which a series of breaches arose that the contractor did not justify. In other words, we're going to give you a work order, claim you're in breach, and everything that's associated with that work order, any other obligations associated with that work order, including the change of the notification provision, we're going to consider that a breach too. It's not sincere to argue that there were a plethora of breaches. There were two. I also heard during Mexico's opening that, oh, these are just service contracts. Again, read the contracts. Definitions are very important. Our obligation, and this is for the 821 contract, our obligation was to perform work, a defined term. Not services, work. Look at the definition of work. Services is included, but it's not the only thing. Now, this is one, and sorry for the snapshot from a photo, but I wasn't able to get the transcript. This caught my attention for several reasons. This is what I heard. Remember, I explained to you in my opening about this fake work order. I told you the movement of drilling equipment. It showed that there were 4 wells assigned to Weatherford, one of which was the Coapachaca 1240. Those 4 wells, Pemex ended up getting a permit for. I heard during the opening the word Weatherford and immediately caught my attention. Weatherford, according to the opening by Mexico, gave information to Pemex to obtain the permit. That tells me two things. One, someone has information that I don't have. You ordered that information to be disclosed. I did not know about that until 1.5 hours ago. And that angers me. 2, it shows we were right. This well was assigned to Weatherford. It's pretty clear. Why else get the information from Weatherford? And with that, I'm going to turn it over to Mr. Derman.
The good news is I only have one slide. The bad news is I can talk for a long time with one slide, but I'm not. It struck me during the opening that Mexico presented that they discussed specifically the board of directors of Pemex. And I quote, and this was at 2/22/20. it was said, and the punctuation is going to be wrong, but it is true that the board of directors includes a public officials, but also independent worth board members. And the Director General of Pemex is appointed by the Mexican executive branch of the government. And it continues on. And so I thought this is interesting in light of Pemex's argument where it says, and I show you at paragraph 70, they say, to mitigate these effects, and this is the difficult times that were occurring in the 2014-15 period, the 2015 Board of Directors of Pemex issued a minute. And in this minute, they mention several measures. And I bring your attention to the bottom three. Negotiate and agree on modifications to the terms, amounts, rates, and in general, any stipulation established in contracts entered into by Pemex and or its subsidiaries that would reduce cost and promote efficiencies. So here we have the Board of Directors of Pemex, where the Director General is appointed by the government and the board is consists of independent and Mexican government officials, but it is controlled by the government. And to formalize early termination of contracts and to ensure that all contract terminations were achieved under the best possible conditions in accordance with the Pemex budget. And that's what they did. We didn't know this, but that's what they did. The Pemex board issued an edict, and they approved this, and the members of the Pemex management and the respective professionals acted accordingly. And we, Jim Finley and Luis Carrion, were impacted in a very negative way as a consequence of how this resulted in the reduction of the work orders and in the request to delay payment from 20 days to 6 months, to extend contracts, and ultimately to cause their business to be so financially stressed that they couldn't continue any longer. They achieved their result. But they achieved the result at the expense of their contractual counterpart, and they shouldn't be allowed to escape that liability. That's, again, what the NAFTA and the USMCA is here to protect against. But it was clear what was intended by Mexico in their pleadings. So with that, that's the end of our rebuttal, and we welcome any questions that you might have later for us.
Many thanks, Mr. Derman. So we are now again ahead of schedule, and we break nonetheless for, I think, 30 minutes for respondent to prepare its rebuttal in turn. So we'll resume at, say, 4:52. Okay.
que decía los actos no son autoridad. O sea, es una tesis muy importante. Todavía. Explícanos la cita que acabo.
Y está en la lista de no.
Él le puede quitar la casa.
aquí no sé si me acuerdo, pero yo fui buscador, te bajé 5 veces porque te bajé 5 veces. Y todos están en cabo de sol. Está en cabo de sol, la injerencia y la
my phone's in like dark mode too, so I don't like the white stuff, the white streak.
These lights?
The two slots, yeah.
Yeah, that's fine.
Apologies on the part of the tribunal because it was us who were delaying the procedure. So now is the time for Mexico and for responding to make its own rebuttal. So, señor Bonfiglio, cuando quiera.
Gracias, señor presidente. Trataremos de ser.
Thank you, Chair. We will try to be very specific in our response to what the claimant put forward just about half an hour ago, also because it's been a very long day. The reality is that the presentation by the claimants and the rebuttals that we heard were focused basically on factual matters having to do with the measures that they consider to be in violation of the treaties under which they have presented their case. But once again, the reality of things before this tribunal is that they omitted the 14 jurisdictional objections raised by Mexico. Instead of taking advantage of the opportunity to refute each of these, the claimants preferred to focus, I repeat, on factual aspects. And here there is something very important that we wish to convey to the members of the tribunal. This is the first case that to be resolved under the USMCA. We see this as a major responsibility because the USMCA reflects the consent and the agreement that the parties to the treaty agreed to establish. And there are some very specific rules that were agreed upon by these three countries. The claimants improperly put forth their case under two distinct treaties. And to date, they've not been able to explain this situation, nor have they been able to justify before this tribunal this way of acting, which we consider to be completely out of place, which would be a basis for the tribunal to have to find that it does not have jurisdiction now. Getting into some of the aspects that were raised by the claimants, I'll begin by the question of consent and waiver. This aspect is extremely delicate, and it even required the United States to find it necessary to speak in this arbitration in order to inform the tribunal of its position, which was one of the 3 points that it raised in its arguments to this tribunal. And the reality is that the claimants did not even try to refute the arguments of the United States, much less the arguments put forward by the respondent. The reality is that the arguments that we are able to hear from the claimants are futile regarding lack of consent and waiver by Drake Finley. It's clear that if a waiver is not presented with a request for arbitration, then consent is not perfected or formalized. And members of the tribunal, please, the dates speak for themselves. The request for arbitration was submitted on 25 March 2021, and it was not until 14 April of 2023 that the claimants bothered to submit Drake Finley's waiver. This you can see reflected in Annex C 48, or C-148. This delay reflects negligent action on the part of the claimants, which they seek to minimize in this arbitration. Now, as regards prescription and the definition of covered investments, it seems that the parties are speaking of completely different cases. We simply don't understand how is it possible that to this day the claimants say that the 3 contracts, 803, 804, and 821, continue to be in force. In their refutation, the claimants presented 3 overheads seeking to argue that the contracts continue to be in force to this day. And members of the tribunal, we are basically before a fiction that the claimants have tried to develop in order to justify the tribunal's jurisdiction, which, in our view, doesn't work and is not successful.
Sobre la fianza.
In connection with the drama bond, and I'm saying this with all due respect of claimants, it appears that they do not understand the nature of a commercial bond. The nature of the drama bond under the Salini test means that it is not an investment under Article 25 of the Exit Convention. It's as simple as that. The drama bond is simply a commercial contract between a bonding company, in this case Dorama, and the debtor companies, Drake Finley, and Drake Mesa. This is a surety under Clause 10 of Contract 821. We heard claimant's rebuttal, and the claimant submitted a series of allegations trying to justify that the Dorama bond is an investment under the Salini test, but it only includes the element of contribution of the Salini test. Claimants also showed on the screen an excerpt of waste management. It's on the screen. But this requires that one has to previously show that an investment, and members of the tribunal, this is not the case here. You're not before an investment, and much less a violation of Article 1105 of NAFTA. Before moving on to a different issue that was dealt with by claimant. When they talk about attribution, I'm going to give the floor to Mr. Becker. He's going to talk about what happened in connection with the alleged investments by claimants.
Mr. President and members of the tribunal, we've had this extraordinary circumstance in which the claimants were allowed to submit hundreds of pages of new evidence into the record just 2 weeks ago. We had to speculate about what type of arguments they were going to make based on using those documents and why they chose not to submit certain various other documents. We did our best to quickly add some responsive documents, but I have to say we're at a disadvantage here. But getting back to the specific issue of the evidence of investment, one thing that the claimants made very clear today, and they said it several times, is that this case is for Jim and Louise. And by that they meant Mr. Finley and Mr. Kernian. The problem for the claimants, however, is that Mr. Finley and Mr. Kernian are not claimants in this arbitration in their personal capacity. So when claimants counsel says that Mr. Finley and Mr. Kernian created various entities to carry out the projects, they're intentionally vague. When you review the invoices, you will see that the purchasers are not Finley Resources, MWS Management, or Prize Permanent. The buyers were different entities, primarily Drake Mesa LLC, a Wyoming entity, and Drake Finley LLC, a Texas entity. They're not related to the Mexican companies. We'll show you two examples right now, and we'll get into this in more detail later in the week. But we're going to start by going to Exhibit 158, page 63. So you'll see on the screen here, this is an invoice for one of the rigs. Right? The exhibit number is Exhibit 158. This is this long exhibit, about 600 pages, that the claimant dumped in with all the a smattering of invoices. So if we see here, up in the upper left, that the buyer was Drake Finley LLC. This is this entity I mentioned before. The claimant hasn't mentioned this entity in the statement of claim or in the reply. Right? The first time, the only time it's come up now is in these invoices. And if you'll scroll down a little bit, just so we can see, so here's a rig. I guess the total price is about $592,000. All right, let's go to page 97. All right, here's another purchase made, again, sold to Drake Finley in Fort Worth from Ameritech Industries. And if we'll scroll down a little bit. All right, so $53,000. Scroll up again just so we can see what this is. All right, so it's an oil field building. Again, the purchase is by Drake Finley, LLC. Now, 2 weeks ago, and this wasn't included in the document of production, we finally saw for the first time some records of imports into Mexico in the name of Drake Mesa SDRL DCV. And I'm going to refer to that entity as Drake Mesa Mexico for convenience. But there's no evidence in the record that Drake Mesa Mexico ever acquired ownership of the equipment. The pedimentos that the claimant submitted are government documents that have to be submitted when you make an importation. In the U.S., we call them entry documents that set out who the foreign exporter is and the foreign importer and the value and what have you. But they don't say anything about who owns the equipment. So claimant's counsel was wrong when he made that allegation earlier. So based on the evidence that's currently on the record, all we can see is that U.S. entities that are not parties to this arbitration bought equipment to be used in Mexico, but didn't sell it. The claimants were also clear today that MWS lent equipment that it already owned for use in Mexico, and that Finley Resources and MWS sent some of their own employees to Mexico to help. But lending equipment and sending employees is not an investment. and Drake Mesa LLC and Drake Finley LLC are not claimants. Now, claimants were more open in discussing that the real estate that they are talking about was bought by a different Mexican company named Baku, which apparently is ultimately owned by Prize indirectly. But Prize didn't bring a claim on behalf of Baku. So it is also not part of this arbitration. I want to sort of summarize by pointing out that the applicable agreements to arbitrate here are NAFTA Chapter 11 and USMCA Chapter 14. Those agreements to arbitrate contain express and specific requirements, which are not complicated to understand. The tribunal cannot now let new parties into the arbitration, such as Drake Mesa LLC, Drake Finley LLC, and Baku, and especially Mr. Finley and Mr. Kernian in their individual capacities, without completely disregarding the plain language of the governing agreements to arbitrate. Thank you. I'm going to pass back to Mr. Bonfiglio.
Gracias, Señor Becker.
Thank you, Mr. Becker. Let's move on to a different issue, the issue of attribution. The claimants recognized that other private companies have entered into the same types of service agreements that they entered into with Pemex. This leads us to conclude that the claimants alleged that some specific terms of the contracts signed with Pemex somehow change the nature of the contracts. We consider that there is no legal foundation for this argument. We consider that the legal issue that the tribunal must examine has to do with the nature of the activity performed. We would like to guide the tribunal and show footnote 318 of our rejoinder, where basically we explain that if an activity may be carried out by non-governmental institutions, and we're talking about commercial type of matters, iure gestionis, this is not done under iure imperi. You can see these concepts in our rejoinder. And this means that Pemex was not exercised in any kind of regulatory or administrative authority. It was not exercised in any kind of governmental authority under NAFTA and the USMCA. For example, to award contracts, to conduct acts under those contracts, or to defend itself in court proceedings. These things are not part of the iure imperi. The USMCA and the NAFTA have a specific regime on attribution. This cannot be minimized. With all due respect, it appears that the claimants have not understood this. We could see on the screen during the rebuttals a section of 821. For ease of reference, this was R3. This is for the tribunal. And it was shown on the screen, and they showed in the definition of work, R3 at page 96. This is irrelevant. The purpose of 821, like contract 804 and 803, well, the purpose of those contracts was to provide services. Throughout the arbitration, the claimants have considered that they were themselves service-providing companies, and they have compared themselves to other companies that render services to PEP. 821 in particular was structured so that when PEP required a service of this provider, this was to be done via work orders. Once the work orders were fulfilled, then PEP had to pay a compensation that was agreed upon under the contract. This was the way in which the contract worked. It was as simple as that. In connection with Weatherford, respondent regrets the confusion about what we said during our opening statement, and this confusion is born of what the claimants said at paragraphs 363 to 367 of the statement of claim, where the claimants indicated that that well had been assigned to Weatherford, to that company. The name of the contractor is not relevant. The name of the contractor that carried out and the work order is irrelevant. But the resolution of the National Commission of Hydrocarbons, and it's on the screen, and this is C-101, well, here it shows that a contractor, apparently Weatherford in this case, provided some information required by Pemex to obtain the permit and then to be able to drill this well called Coapechak. We would like to apologize if this caused some kind of confusion. Now, in connection with national treatment, I'm not going to repeat all of the arguments and that we have put in connection with the deficiencies related to the claim on national treatment under Chapter 11 of NAFTA and Chapter 14 of the USMCA. But the claimants did not meet the three requirements that need to be met so that a violation of the principle of national treatment may be established. The comparator that they used, Zapata and Integradora, well, we have no evidence as of today that they are controlled by Mexican investors to be able to allege that there was discrimination and to allege that the right not to discriminate was violated. These facts were ignored today, and the claimants are trying to distract the attention of the tribunal so that it can look at other reasons. This tribunal does not have jurisdiction to decide on contractual matters, but as to the allegations by claimants of Clause 15 of Contract 821, we have felt the need to say that 821 was deemed terminated because some of the assumptions of that contract were breached. I would like to end this rebuttal by saying that we do not agree with the allegations by the claimants. Many of these allegations are incendiary in nature. They talk about an alleged fictitious or false work order, as claimants have classed it. We do not concede that there was this very infamous meeting in September 2018, and we regret very much the accusations that were made in connection with Mr. Rob Kiosayan. We're not going to behave in that way. We're going to show clear facts that show that the tribunal lacks jurisdiction and that there is no violation of NAFTA and USMCA. This is the first USMCA that is solved under the investor-state dispute resolution proceeding. So I have to say that these things have to be very carefully dealt with by the tribunal.
The tribunal to put to you the questions we have. I don't know whether France or Alain, you want to go ahead or you defer. You defer to your colleagues. And Franz, you want to go first? Or?
I'm happy to go first if we can.
Please.
I don't have that many questions. More matters of clarification.
Claimant in its page 82 of its presentation refers to Exhibit C 148, which was a list of assets. And I just wanted to know from you what kind of a document is that, because I didn't know where it came from. Is it a SAP document, or is it an Oracle database? Because it's just a listing, but I would like to know what kind of document we're talking about.
That document is a document that was a QuickBooks ledger, which would be similar, I think, to SAP. And it was kept up throughout the investment, and Mr. Finley will testify to this tomorrow. And throughout the investment, that document was kept up by inputting each specific invoice into the document or into the QuickBooks, and then scanning that invoice to that corresponding entry. So it was a QuickBooks ledger, which I think is similar to SAP. QuickBooks is the company, and that's what Finley Resources used, Price and MWS, to keep up with the investments they were making in Mexico.
Okay, thank you. Yeah, the second question was, I think it came up afterwards in respondent's presentation, but it relates to a matter that came up also in your page 107, or I wrote it down there, in relation to your request for consolidated financial statements for Pemex. And respondent asserts that there's an inconsistency in your pleading, because on the one hand, you are pleading that Pemex would have had no budget, and that's the reason why the whole, that would explain Pemex conduct, etc. And on the other hand, you would like to have an adverse inference, or at least that there was no budget when the so-called fake work order was issued. But then you asked the tribunal to have an adverse inference that there would have been budget at the beginning, or when the contracts were signed, or at a certain time when the contracts were signed, where the breaches were committed. Can you explain a little bit more this inconsistency? I think confusion, like I'm not going to cast motives here, but I'm not sure it's as confusing as maybe the issue that was raised. As we explained, before entering into these contracts, Pemex had to get approval, I think it's the Congress, to enter into the contract, and it was given a specific amount. We asked, and you ordered, for us to receive the ledgers showing the specific amounts, because there's been debates about the total amount of the investment and the contracts. That's what we wanted. We didn't get it. We were, the inference to be drawn there is, and again, we asked for the general ledger showing where the money was going. It was in the account. Where did it go? Because it didn't come to us. And we were told no budget.
Okay, but my question to you is the adverse inference, is it not different depending on the timeline? Because you make different allegations. On one point, you make an allegation that budget should have been or was there, or the inference should be that the budget was there, and then later on you plead that there was no budget. So which inference do you want the tribunal to draw?
Yeah, it's not. There's. If Mexico wants to agree with us that there was no budget, we could avoid this easily. I would like to know where the money went, but I think you should draw the inference that there was no money, at least for the 821 contract, when that work order was issued. They couldn't pay for it.
So that's the particular inference that you want. It relates just to the assertedly fake work order, not to anything else, not to any other time period.
Well, Mr. Sherman, I wish I had the other time periods too. If they tell me that they didn't have a budget during that time, I'm happy to accept the admission. But again, it's kind of hard when you have an opponent that you say, is this true? And, well, we veer off into a different territory and we don't really address the issue.
These are the two questions that I have for claimant, and I have questions to both parties and to respond, so perhaps I can hand over to...
You hand over to...
Yeah, and I'll have then questions to respond.
Okay. So, Mr. Bonfilio said that this is the first time the tribunal is going to rule on the USMCA treaty. So probably it's good for us to have an initial discussion of what some provisions in both the USMCA and the NAFTA treaty mean. And let me start with one question which is raised by respondent concerning Article 14.2.4 of the USMCA. I don't know whether you, Annalise, could you, any of you, put on the screen that Article 14.24? Sorry. Yeah, we already saw it. It's 14.2.4. Yes. At the bottom, you may see the use of the conjunction or at the very bottom in the. And as far as I understood, respondent claims that it or is what a logician would call an exclusive or. So it's either A, B, or C, but not all of them. So that's, for a logician, that's an exclusive or, as opposed to an inclusive or, in which when you say something or the other, in logical terms, that is true if either the first element or the second element are forthcoming, or both of them. Just to express myself more clearly, and I'll switch for a little while, with the permission of interpreters, to Spanish. In
the Pan-Hispanic Dictionary of Doubts, there is a section that deals with the conjunction O, and when it is exclusive or inclusive. In the Spanish-speaking world, the conjunction O is inclusive in the following sentence. In this drawer, you can keep notebooks or binders. One thing, another, or both.
Use the or. That proposition is true if the first element is forthcoming, or the second element, both. So in logical terms, or is always inclusive, because it allows for the proposition, logical proposition, to be true if the two. And my first question, addressed to respondent, but of course Clemens can later on chip in, is am I right in assuming that you say when the Article 14.2.4 uses the or before Annex 14A, that or means that it should be one of the three, but not two of them? And if that's the case, why do you say so? On what basis do you think that or is an exclusive one and not an inclusive one, as a logician would typically say?
Gracias por la pregunta, señor.
Thank you so much for your question, Mr. President. This question in particular is closely linked to the first objection that I put to the tribunal today. we consider that this objection applies to both the NAFTA case and the USMCA case. Now, what do we want the tribunal to understand out of this? If we look at 4, it says here, for greater certainty. And then then it says,
accionista Smith solo podrá presentar.
an investor may only submit a claim to arbitration, and then it provides the 3 options under 14C. And this revolves around the issue of legacy investments, and then 14D or 14E. What is it that we would like to convey to the tribunal? The 3 parties of USMCA established that for greater certainty, an investor may only submit only one claim under only one of these annexes, and the terminology speaks for itself. As you said, Mr. President, this conjunction or explains that you can only submit a claim under only one of these annexes. This would be the answer. Mr. Becker would like to add something, sir.
Thank you. Just because we're discussing the English text, we just want to sort of make clear that where it says an investor may only submit a claim, that modifies the or, right? So you wouldn't be saying you wouldn't be saying only if you meant or to be conjunctive. It's a limitation.
I have just one question. Would you, rather than not use plain English, wouldn't you use either? So you would have may only submit either a claim, then you have the rest? Because the only is you may only submit one of these 3. But if you have a neither, then it's clear one of the 3 and exclusive of the others. You would use a neither to make exactly the point that you're making.
I agree that's a potential alternative way to write it, but I think it's not typical to use either when you've got 3 options. People usually say either or.
Right.
Right? Not either or. But again, we think, with the greater certainty and may only, we think in combination with the rest, makes it clear that it was intended to mean only one of the 3.
Yes, but again, to challenge logically that point of view, couldn't you interpret the only as meaning that any claim under the treaty should fit under one of the 3 buckets? That only might mean necessarily under one of the 3 buckets, Annex C, D, or E, without necessarily implying that you cannot put together claims under different buckets. Because, let's recall that both in English and in Spanish, there's an expression which many lawyers dislike, which is the and or, which is used, and there are rulings criticizing that approach, whereas there are advocates who say that that makes sense because the or, both in English and Spanish, is ambiguous. It's not clear whether it's disjunctive or conjunctive. For elogiation, it's pretty clear that is conjunctive. So you can have under or the 2 parts of the preposition being true, and the entire preposition is also true. It's not exclusive in logical terms for elogiation. So I see your point that you see that the or at the very end is disjunctive to the extent that is qualified by the only at the beginning of that. Again, I'll think it over, but I don't think it's fully persuasive I think claimants will have an opportunity to come back on this point. Alain.
Yeah, just to pursue on that, couldn't a relationship between a claimant and a respondent, an investor and the state be more complex than just one or the other? Can't you have a variety of relations, each entering in one of the categories of paragraph 4?
Actually, no, because, for example, I mean, there's a clear distinction between 14D and 14E, right? You can't bring this, right? There are more limited bases for claims under 14E than there are under 14D. And if you had the option of bringing claims under both of them based on the same facts, you would be basically erasing 14E.
You nearly persuaded me for D and E, but not C. I think C is...
Well, but there's timing issues under C, right? Because then you'd be suggesting you can bring claim based on the same facts under both the NAFTA, which was terminated in July 1st, 2020, and the USMC, which took effect on that day. And there's very specific time limitations, as we know, under 14C. You have to have an investment existing as of that July 1st, 2020, to continue to go under the NAFTA. And claimants have to make a choice. You don't have, this also relates to the fact there's no provision, as we've discussed it at length, allowing self-consolidation of claims made under the different treaties, which again you would be erasing if you just said you could bring claims under all three.
Señor Presidente.
Mr. President, if you allow us to add some comments to the question by Professor Pelé and our explanation by Mr. Becker. You said it in an illustration manner. Each annex is like a bucket, and each bucket has its own subject matter and rules, and also objective. And let us recall how this paragraph begins. For greater certainty, an investor may only submit a claim. And as we were able to explain it in our presentation, the tribunal is not faced with just one claim, rather three. And clearly, claimants have not been able to explain whether the parties to the USMCA actually granted their consent to do it in this fashion that, in our opinion, was deficient. They presented the case in a deficient manner.
Claim that a claim in paragraph 4 means just one with a single legal basis, not with different ones. But what would be the reason for that provision in the treaty? Because one would tend to think that in terms of efficiency, is far easier for a claimant to be able to include in its claim, as is commonly done in many other cases, different separate claims with different legal bases. And why would the countries signing the USMCA would have preferred to have for claimants having claims under different treaties to start separate proceedings, arbitration proceedings? What's the rationale for that interpretation that you are making of this paragraph 4?
Sujeto a dar más explicaciones.
Subject to further explanation, and also going back to what we said in our memorials, and as our colleague Steve Becker mentioned, the aspect of time is a situation that needs to be considered, and that is reflected in 14C. Another situation is that under 14B, there are substantive rights with a text that is different from what we see under 11 of NAFTA, and 14E, as we explained, applies to protected, covered government contracts. That is a new concept and another specificity. The dispute settlement mechanism under Chapter 14 of USMCA does not apply to Canada anymore, rather two countries that are party to the USMCA. So trying to offer some facts to the tribunal, the negotiation of the USMCA that is reflected in Chapter 14 under this treaty comes from a negotiation that intended to perfect substantive obligations by establishing key procedural requirements, but each annex applies to specific aspects, and your example of the buckets is key to understand that, or to explain that these annexes are different.
Señor Presidente.
Yes, please.
Sorry. I just wanted to add one short point. For it to be conjunctive, the parties could have very easily just substituted the word "and" for "or," right? That you could bring a claim to under arbitration under 14C, 14D, and 14E. But they didn't do that. So we would submit that the actual words that are being used have to be given their normal meaning. Thank you.
Yes, that's the thing, that "or" is very tricky in legal terms because in common parlance it's not clear whether you apply the logician approach of a conjunctive or a disjunctive. But before I move to my next question, I don't know whether claimants want to say anything.
Briefly, we do, and I think I agree with you to the extent I understand where you're going. We should look at this article in context of what was happening. The treaty parties were giving investors a choice. You have 3 ways to bring a claim. If it falls under the NAFTA, we're going to preserve your rights. File a claim under NAFTA. We have a new treaty, the USMCA, which we're going to separate in 2 routes. If you fall under something that we're going to call a covered government contract, you go one direction. Everybody else, you go the third direction. But that doesn't mean you can't have going in both directions, particularly when you have an investment that crosses, if you will, the time barrier between the 2 treaties. It's not you do this, or this. It's we have 3 options that we're giving you to make a claim. I really don't think it's all that complicated. I tend to look at it, and I think Mr. Bonfilio mentioned it. What party is missing from the USMCA? Canada. If you think back, why would we have these options? It's to protect Canada from coming into investment claims it wanted out. But that doesn't mean, at least I hope I'm not hearing, that Mexico believes it could cut off investors' claims who had claims under NAFTA, because that's the logical result of the argument that they're proposing. That can't be the case.
Okay. I move to my next question, which is also on this same treaty, and it's the famous footnote 21. And I invite the 2 parties to elucidate myself and probably enlighten myself and the rest of the tribunal as to the actual meaning of that footnote, particularly bearing in mind that claimants have argued that it's contradictory to paragraph 14.2. So if you could discuss, both of you, or either of you, as you want, what's the real meaning of this footnote 21, that might be helpful for the tribunal. Who wants to take the floor first? Respondent or claimant? It's addressed to both of you.
Un segundo, señor presidente. Estamos buscando justo.
Just a second, we're looking for that information on the computer.
Yes, it's at the bottom, but if you could blow it up.
All right, so we have to, again, paragraph or footnote 21 to paragraph 1. So we could scroll up to paragraph 21, please. So this is discussing basically what we call with respect to a legacy investment, the submission of a claim to arbitration under the NAFTA 1994. And if we go back down to the footnote, what the footnote says is that Mexico and the United States are saying if an investor is eligible to submit claims to arbitration under paragraph 2 of Annex 14E, they can't bring a NAFTA claim. And then I would submit to you this reinforces what we were discussing before. It's the or is disjunctive. You can't do both, even if you qualify under both.
Your practical conclusion in this case is that the claim concerning contract 821 should have been made under Annex E.
Well, if they're claiming they're qualified to bring it under Annex 14E, they're admitting that they weren't authorized to bring it under the NAFTA.
Otro aspecto a considerar.
Another aspect to bear in mind, Mr. President, is that this footnote 21 should be analyzed bearing in mind, and we can look at paragraph 6. What needs to be understood for existing or legacy investment. In our consideration, 821 was no longer a legacy investment with the enforcement of the USMCA, that is to say, July 1st, 2020. So these are the situations that led us to present so many objections to the jurisdiction, because it was not considered by claimants. This language under 14 was not considered at Annex C and 14E. Thank you very much.
Was forthcoming on January 1st, 2020. So let's assume that as a hypothesis, but let's further assume that the claim concerned an act which took place before January 1st, 2020. In that setting, in your view, which of the two treaties might be applicable, 14E or NAFTA?
Si ese fuera el caso, tendría que explicar.
If that was the case, if they need to determine whether they have a covered government investment, 821 is not. So we see each other in the need to perfect argument. We don't want to perfect arguments by claimant, but those arguments are so deficient because we do not understand whether it had to be under Annex C or 14E. But if we had to be in a hypothetical position, it could be that it should have been under 14C. But we do not know that because it wasn't clear whether they had a legacy investment. And on the other hand, all of the measures that took place do not comply with the thresholds established in Chapter 11 of the of NAFTA or 14 of USMCA.
When the alleged violation was argued to have taken place, right? So if the alleged violation took place when the NAFTA was in effect, and you're still within the 3-year limitations period, right, you may be able to pursue under the NAFTA. If you're alleging violations that took place after the NAFTA ended and the USMCA took effect, then you're limited to alleging a violation of the USMCA.
Yeah. So assuming that all the other conditions were met, including there was an investment at the time when the second treaty entered into force, and then if the violation took place before the new treaty entered into force, then claimants should have gone to 14C, legacy investment, as they actually did. So the question hinges, in your view, not so much on whether they misuse Annex 14C, but whether the other conditions, an existing investment at the time the USMCA treaty entered into force, and all the others were forthcoming or were not.
And they're relying on alleged violations that took place in 2020.
No, of course.
Yeah, of course.
Yeah, assuming there was a violation.
No, but if they're basing their claim on alleged violations that took place after the USMCA took effect, then they're going to be potentially captured by this footnote 21.
Yes.
If they meet the conditions for that annex.
But let's assume that the claim or the violation concerns only, say, the ruling on October 4th, 2018. Then in that case, assuming by hypothesis that all the other conditions are forthcoming, then claimants should go to Annex 14C and present a NAFTA claim as a legacy investment because the quote-unquote violation, the alleged violation, took place before the new treaty entered into force.
Under that hypothetical,
Yes.
yes, we agree.
We are always talking, my case and the rest of my colleagues, purely hypothetical to test what's the meaning of the treaty in different scenarios.
Y nada más para ponerlo muy en claro también,
And just to put it very clearly in a Spanish version, the words you said, if hypothetically there had been a legacy investment and the measures had taken place before the entry into force of the USMCA, that is to say July 1st, 2020, it could be said that the path to follow was 14C. But we'd like to make it very clear that this is not clear. This was not presented under these circumstances. This is not the way claimant presented this, but we would like to leave it like this under the way it was presented.
Say?
Well, claimants, not Pemex, but that's okay. It's been a long day. To be candid, we studied these provisions exhaustively before initiating this arbitration. If you were to ask the United States, they weren't able to articulate. We sought our government's advice. What does this mean? What do you do? Their answer was very similar. There's nothing in writing. It was a telephone call. Their answer was very similar to what you're hearing now. The best we were told, and it really wasn't counsel, but for what it's worth, if you can bring a claim under the USMCA, if you're eligible to do it, that's what this footnote is encouraging you to do. We want you to move away from the NAFTA into the USMCA. So, well, what do you do when you have a breach, what we contend is a breach that occurred during the NAFTA? And at the time we filed, to be honest, if we all want to be honest with each other, we were not receiving additional actions. That did not occur until after we filed. What do you do? Well, from what I'm hearing, I think maybe we take one claim and raise that one claim under the NAFTA and under the USMCA. I don't think that's what the parties intended, but that's what I'm hearing would be the outcome of the argument. So I think the best you can do is figure out where the breach is, identify where the breach is, and if you, like we explained in the opening, pick a route. If you're breach and you qualify under the NAFTA, you're eligible to bring a claim under the NAFTA. You have time limitations. I appreciate that. If the breach occurs during the effectiveness of the USMCA, bring your claim under the USMCA. When in doubt, if they come under both, go to the USMCA. We weren't in that situation when we filed our claim. I appreciate facts have arisen since we initiated our claim, which makes it increasingly more complicated. And I do think, and correct me if I'm wrong, I think there are other cases right now trying to deal with these issues. Maybe there can be more clarity on it, about how the parties are working through what happens when you have ongoing conduct that if you will, transcourses, I'm not sure if that's the right word, two treaties. But practically speaking, just being plain common sense, what does it matter? These treaties protect investments and provide the same protections. So if we want to call it NAFTA, great. You want to call it USMCA, okay. Effectively, what's the difference in the outcome? At least if you fall under the categories I appreciate when it comes to the USMCA, at least if you fall under one of these covered government contracts. It's the same outcome.
Señor Presidente.
Mr. President, I think it is necessary to request the floor. We just heard claimant ask or wonder what matters. Why does this situation matter? But it does matter a lot, because it is a situation that has to do with the consent by a state party to a treaty. And I would like to recall part of the presentation that we used for the opening today. When the tribunal exercises their potential jurisdiction, they need to do so in a rigid and conclusive manner, but also recalling that the disregard for the consent of a state party to a treaty is a severe dismissal of their sovereignty. So to answer the question by claimant, it is extremely important to prove consent by Mexican state to arbitration of this dispute, and honestly, there is none. There is none because of the deficient way in which this claim was presented. So the lack of consent the consent cannot be disregarded. This is what we heard is something extremely sensitive, and we just want that the tribunal takes the message that takes away the message that this has to be questioned because it is extremely severe.
I must say I am a bit troubled by what you said. You said it doesn't matter, but I just remembered a footnote in your statement of claim, and which is footnote 474, where apparently you did think it mattered, because you say we had no choice. I summarize what it is, a long footnote, but you write at the time it is part of it. At the time they submitted the request for arbitration, Finley and Price understood that they were not allowed to submit a claim under USMCA Annex 14E. If I underline this, is just because I have some problem to reconcile what you just said with your footnote.
And it's a fair comment. If we're doing the hypotheticals, the outcome doesn't matter. But you're right, we had to choose. That's what, again, that's what my telephone call had, and that's what I was trying to figure out with footnote 21. How do you apply this? And it says, if you can bring a treaty claim under either the NAFTA or the USMCA, you need to bring it under the USMCA. So that leads to it's the necessary follow-on on this. Well, should I bring it under the USMCA? Can I? And so I think the relative time marker, maybe is the right word, is when we think the breach occurred. And if you can get in, like I said, if you have an entryway into the USMCA or you have an entryway into the NAFTA, those are your choices. You bring your claim under the NAFTA for an investment, you bring your claim under the USMCA for an investment. I don't think, unless I'm mishearing, I don't think I can bring a claim for an investment under both treaties. The same investor bringing the same claim under both treaties. I don't think that's possible, but I think you can bring different avenues. And I don't think the parties excluded, for me it would be a little unusual to have these provisions contemplating that there's going to be a transition between two treaties with identical protections, that it would be unusual for you to have claims that arise under both treaties. I find that, I wasn't in the room, obviously, when the treaty was being negotiated, but I find it hard that this wasn't thought about, this conduct during the transition.
Right, so when we were confronted with this analysis, we reached the determination we should bring the claim under the NAFTA treaty for 821. The ultimate result, just to clarify, where it doesn't matter, the results, once you're in an investment claim, the results are fairly similar. The jurisdiction, I appreciate, needs to be attended to carefully. But once you're properly within the jurisdiction, the remedies under the treaties are similar, and in our case, more or less identical. So in our case, we thought that the relevant event that was triggering the treaty claim occurred during the before the USMCA in July 1, 2020. So we brought the action under NAFTA.
Mr. Becker.
Yeah, very quickly, just to respond to the point. It does make a difference, because if you're under the USMCA and you qualify under 14D and not 14E, you can't bring a claim for fair and equitable treatment, right? The parties to the agreement restructured how they wanted to deal with investment claims, under what circumstances. As we've discussed, Canada was moved out. There are differences between the treaty. It's not exactly the same.
We're not saying they're identical. It's just the point that the entry into the treaty, whether you go through the NAFTA or you go through the USMCA, provides remedies, either under the USMCA and under NAFTA, and I'm not disagreeing with you. There are different remedies. Getting back to this point, our decision was that the right choice to enter into this treaty dispute was through the NAFTA on 821, because the relevant events took place in 2018. No more complicated than that.
And could the tribunal substitute one ground to the other?
I'm not sure you have a prohibition against that. I'm not sure it's needed in this case, but if it is, I don't think there's a prohibition against doing that. Look, I wish that this transition had been more thoughtful in the text of the USMCA, but here we are, and dealing with the words that were given to us by the contracting parties. And I think the most logical, again, we tried to figure out a logical path for an investor to navigate the choppy waters.
Well, let's continue I'm going to tax your patience, so bear with me. But I think this is the first time tribunal will grapple with these treaties. And let's move now to two twin articles in NAFTA and the USMCA, which is, in the case of NAFTA, Article 1503, paragraph 2, which is by and large similar to Article 22.3 of USMCA. And I'm intrigued about the meaning of the words wherever in NAFTA and if in the article in US. So if, I don't know whether someone can show on the screen Article 1503 on state enterprises of NAFTA.
Lo haremos en un momento, señor presidente.
Well, we can do it in just a second, Chair. $15.03.
Wait
Huh?
for
Yes. No, I would say that if we go up, this chapter 15 is on competition, policy, monopolies, and state enterprises, which is a chapter different from chapter 11, which is on investment. And when I read paragraph 2 of Article 1503, it says, each party shall ensure through regulatory control, administrative supervision, or the application of other measures that any state enterprise that it maintains or establishes acts in a manner that is not inconsistent with the party's obligation under Chapter 11 and 14, wherever, and this is the key word, wherever such enterprise exercises any regulatory, administrative, or other governmental authority, etc. I would tend to think that here it says that if you are a public entity and you are exercising those powers, regulatory, administrative, or other governmental authority, you are subject to Chapter 15. That's pretty obvious. But my point is, does that imply that if you are not exercising regulatory powers, and you are in a state enterprise, you are excluded from Chapter 11? So to what extent Chapter 15 qualifies Chapter 11? That's my question. And I could raise the same question with Article 22.3 of the USMCA, which rather than wherever uses the word if. But the principle is exactly the same. To what extent the chapters on specific obligations concerning competition and the exercise of regulatory powers have a bearing on the chapter on investment and dispute settlement? So as I for one have more questions, but probably we can finish today with this one, and to the extent that Mr. Kyoseyan is not coming on Wednesday in the afternoon, we'll have plenty of time to continue with this round. But let's finish with this last question which I've raised, and Mr. Becker, probably you want to respond right now.
Sure, Mr. President. So starting with the NAFTA, if we look at Article 1116, for example, it's expressly states, and Article 1117 is similar, but in 1116 discusses that an investor of a party may submit to arbitration under this section a claim that another party has breached an obligation under Section A, which is the setting out of the national treatment and the other obligations. It says, or Article 15032. So it expressly ties into the provision of Chapter 15 that you cited. And we discussed this in the submissions, but the point simply being that the NAFTA and the USMCA establish a lex specialis in terms of the responsibility of a party for its state enterprises. And it's exactly how you summarized it. If a state enterprise is not exercising, or if the allegation does not relate to the exercise of regulatory, administrative, or governmental authority within the meaning of 15032, it's not covered by Chapter 11. So if a state enterprise is regulating other parties, if it's been delegated authority to issue permits for other unrelated work, or it's levying taxes, for example, and those sorts of governmental functions, its actions are potentially subject to Chapter 11. But as in this case, if the state enterprise is simply entering into commercial contracts, it is not. That is not a regulatory, administrative, or governmental authority within the meaning of this paragraph.
Okay, many thanks, Mr. Becker. Unless you want to take the floor, and subject to the control of my colleagues, I don't know whether they want to raise on this point on any final issue.
No, I have some questions, but I can wait until Wednesday. I'm not that impatient. But I would like to know what happens on Wednesday precisely, because you said apparently you reserved that more or less for tribunal questions, but you also we also decided in the agenda that we will try to have the examination of the claimant's experts that afternoon. So,
well, my understanding is that we offer both parties the possibility to change by common agreement the revised timetable that we sent out on Monday last week. You didn't, so the tribunal assumed that the revised timetable applied, and you didn't agree to moving to Wednesday any expert report, so that we take both experts on both sides together on Thursday, the last day of. So there will be no examination of experts on Wednesday, and we will have all the afternoon to raise questions. Is that a response to your query, Alan?
It is a response.
Oh, okay.
I would not have given the same, but I don't object.
So, unless Annalisa, is there any housekeeping issue to? So this brings to an end today's inaugural session of this hearing, and this is just to recall that tomorrow, rather than 9:30, we'll start at 9. Before on Wednesday, we'll start at 8. So for the time being, tomorrow we're still safe. It will be 9, and we'll have the examination of the two witnesses from claimants, as well as the direct examination of Mr. Lustano. So on that note, I thank you for your participation today, the interpreters, the stenographers, Mr. Muino for being kind enough to make her presentation today. And so we are finished for today, and we'll see you tomorrow at 9.
Gracias, señor presidente. Que tengan muy buena tarde.
Thank you, Chair. Have a nice evening.